So if anyone would like to watch it again, this is being recorded. And we're going to have a quiz review because there is a quiz this week. Any questions before we get started? Great. So this is our first introduction to the Statute of Frauds, which I've always thought was very, very intriguing because in common law, contracts do not have to be in writing. All you need is offer, acceptance, and consideration, and you've got a valid contract. However, American law was brought over by our founders from England. England has a statute of frauds. Under the English common law, 6 types of contracts had to be evidenced by a signed writing to be enforced in a court of law. The purpose is to avoid fraud, right? If you have a contract in writing and it's been signed by the party that you're trying to enforce it against, it's much more likely that it's not, there's no fraud on the court. So it's called the Statute of Frauds. The Statute of Frauds has been written into the Uniform Commercial Code. So contracts for the sale of goods greater than $500 must be in writing and signed by the party that it's going to be enforced against. There's other types of contracts as well. Contracts for the sale of land. Land is to be very valued in the American and the English system. Everything is about who owns the land, who can control the land, who sells the land, who leases the land. Land ownership is very important, and it's a fundamental concept in our society. Every parcel of land is considered to be rare. So therefore, contracts for the sale of land must be in writing to be enforced. That has been written into statutes by the legislature in almost every state. So almost every state will have a statute of frauds telling you which contracts must be in writing to be enforced. In England, there was a contract for marriage. We don't have those in the United States. But in England, there was a dowry associated with a marriage. So they wanted to uphold a contract for marriage. It had to be in writing to be enforced. Contracts that cannot be performed within a year. A year from now, we may forget what we talked about today. So contracts that cannot be performed within a year must be in writing to satisfy the statute of frauds. Executor contracts, co-signers and guarantors. Anytime somebody signs for the debt of another, that agreement must be in writing. A perfect example would be if you buy a car for your child when they're 16 or 17 years old, and the dealership says, well, they need a co-signer. They don't have enough established credit. They're a teenager. You'll have to co-sign for the car. So if you have to co-sign for someone else's debt, that has to be in writing. Or if you're Jeff Bezos and you own a company called Amazon, if Amazon needs to take out a loan to purchase more real estate and more hardware, Jeff Bezos would be the human being who may guarantee that contract. As a guarantor, oftentimes CEOs of companies or sole proprietorships, the owner of a company will often guarantee a loan that's taken out by the company. So that agreement has to be in writing. So that's what the statute of fraud covers. We have an acronym called MILEGS: contracts for marriage, contracts that can't be performed within a year, contracts for the sale of land, executor contracts, contracts for the sale of goods greater than $500, and suretyship. Let's talk about your memo and how it ties into the statute of frauds. So you have a memo assignment for Module 4. Be sure to use standard memo format. In our example, Jill and Will are independent contractors. They have completed technology projects for people and businesses. They've never sold parts before because they did not want to have to collect sales tax or deal with the paperwork. In the past, they carefully selected customers. Collection of bills wasn't difficult, and they decided not even to use written bids or contracts. What do you see as a problem, Joe, with doing business the way that Will and Jill have done it in the past?
Well, for one, they didn't get nothing in writing, and there's no bid, so there's nothing to. It's more like he say, she said. There's nothing to validate the contract.
Yeah, to me, anything is important as running a business. I would think that you would need to have your contracts in writing. When I lived in when I was in law school, I had a part-time job working for an architect. He was a very important architect, actually, and he had a big project he wanted to complete in Panama, and he would send these bids over to Panama and fax them, offering to do the job. And I was like, why doesn't he talk to a lawyer? He's talking about a multi-million-dollar development project in Panama. We were in San Diego, and I was in this beautiful skyscraper that had been designed by this architect. And all he's doing is dreaming of skyscrapers and designing things. I kept thinking, why doesn't he have a lawyer draft up a contract for this multi-million-dollar development project that he envisions in Panama? And he had already written the blueprint for it. And he never did. And I would sit there, I was in law school at the time, just working. I think I was working like as a receptionist, answering the phone part-time just to make extra money. And I'm in this office thinking, what is this guy doing? And he never did seal the deal. It completely fell through. And I thought, well, the first thing you need to do is hire an attorney and have them draw up a legitimate contract and fax that over to Panama. That's the first thing you need to do. As an architect, he doesn't have the knowledge to negotiate a multi-million-dollar deal. And again, it fell through. It never did come together. So no, it is very important to have contracts in writing written by lawyers. There's a reason why people go to law school and obtain the knowledge. And it's not, a lay person is not in the position, especially when you're talking about a multi-million-dollar deal. Yeah, that needs to be in writing, first of all, and it needs to be more than just a fax going back and forth. So yes, this example of Will and Jill, um, selecting customers maybe that they know really well, and not using written bids or contracts, that's unacceptable. So they realize that, right? And they seek advice from counsel, your supervising attorney, Mary. They decide they're going to sell bigger ticket items, right? Under the statute of frauds, contracts for over the sale of $500 must be in writing or they cannot be enforced. So they decide to hire you and your boss to do some research. So this is research about the statute of frauds in this memo assignment. So here's what you need to do. Find a recent case in Lexis or Fastcase on the statute of frauds. Find a recent article in the Rasmussen Online Library on the statute of frauds. Go to Google. Find a legal blog on the statute of frauds. 4. Find the statute of frauds that's been enacted in your state. Florida, Texas, South Dakota. Find the statute of frauds in your state. For the appellate case on the statute of frauds issue, complete and include an IRAC analysis within the memo. So that's number 1. When you find that case in Lexis or Fastcase, you'll want to do an IRAC of that case. That means you identify the issue in that case, the rule in that case, the court's analysis in that case, and the court's holding in that case. Any questions about that memo? Let me take the time to find a recent case and Fastcase. Let me share my desktop with you, and I'll do that part of the assignment with you just to make sure that we all know how to do it. All right, let me
So can I
Yes,
ask
ma'am.
a question?
Go ahead.
So on the writing assignment where you want us to do the article in the legal blog, do you want that of the part of the IRAC, or do you want us to do it like on a separate?
One memo in order. Part 1 is the IRAC. You find that case and you IRAC only that case.
Okay.
Only that, you know what? Let me extrapolate. Sandra, only a case can be IRAC'd because in a case you'll be identifying the issue before the court, the rule that the court applied, and the analysis the court used and the conclusion that the court reached. Only a case can be IRAC'd. This other stuff can't be IRAC'd. Only the case can. So complete your memo in chronological order, starting out with the IRAC. And really, the instructions should have been written up that way. It should have said, find a recent case in Lexis on the statute of frauds and IRAC that case. So let me do that part of the research with you. I'm going to share my desktop. Open up a web browser. And we're going to take a look at Fast Case. And we're going to find a recent case on the statute of frauds. Tools. So when I need to look up the links, I go under library resources, programs. You all are in the Justice Studies program, Paralegal, and there's a link to Fast Case. And what I want is a recent case on the statute of frauds. And I also want to find the statute of frauds in your state. We're going to go with Texas. Alrighty, so I want, and I'm going to put this in quotations so I can get that term statute of frauds, contracts, and then writing. It's working. It's working. 1,500 results. I only want cases. 1,100 results in Texas. And I want to sort by newest date. I want to know what the courts are saying right now about the statute of frauds. This looks really good. This is probably about real estate. All right. I found a case. And I'm going to scroll through it. And the terms that I searched are highlighted. Answering the lawsuit, asserting affirmative defenses, including that the statute of frauds barred enforcement of a commission sharing agreement. Okay, so this is a case between two people who worked in real estate, and they had allegedly a real estate sales commission agreement where they were going to split commissions. And the question is whether or not that can be enforced under the statute of frauds. No writing memorializing the commission sharing agreement was introduced into evidence. So the issue would be whether an oral agreement for sharing commission between realtors can be enforced. And the rule is going to be that the statute of frauds requires certain agreements to be in writing. And here is section 2601 of the Texas Business and Commerce Code. It says agreements that cannot be performed within a year must be in writing to be enforceable. If the agreement is capable of being performed within a year, it is not within the statute of fraud. So those are your rules. Those are your rules. And then the analysis is how we're going to apply the statute of frauds to this scenario involving this oral real estate commission agreement. Although Castillo sought compensation for commissions earned during a 2-year period, the record does not eliminate the possibility that performance could have been completed within a year. N did not present any evidence that her agreement to share commissions could not be performed within a year. No evidence established that performance under the agreement was for a fixed time period. Rather, only evidence of the potential duration of the agreement to share commissions was Castillo's testimony, which supported an inference that the agreement was effective for the duration of his hiatus. So the court says that we cannot conclusively determine that the oral commission sharing agreement was unenforceable under the statute of frauds because it's possible that that agreement could have been performed within a year. So that's a pretty good case. You want to cite to that one? Knock yourselves out. Any questions about how I found that recent case from September 15th, 2022 on the statute of frauds? So that worked out pretty well. Now what we want to do, and we've already found it, which is this: find the statute of frauds in that state. And here it is. There are many statute of frauds. Here is one right here: Texas Business and Commercial Code, section 2601. Any questions? Okay, so it also asked you to find a law blog on the statute of frauds. I already have that search saved. Here we go. vinthamlaw.com, wiseblatt.com. So these are law firms that are blogging. Must be his law firm. A nice looking man. And I don't want to chat with you. The statute of frauds in business contracts. A highly important part of business is entering into contracts with other businesses for goods or services. Whether you're providing or receiving the goods or services, it's essential to ensure that your contract meets all necessary legal requirements to be enforceable. One requirement may exist under certain circumstances that the contract be in writing. So you want to summarize the law blog that you find and cite to it in your memo. Any questions about that? Great. The internet makes things so easy. So this should be a fun assignment. You know, it really, the key to it is really just following the memo format and doing things in order. And if you do the, you write the memo in the order of the questions, you should be good to go. A recent case in Lexis, IRAC the case, a recent article in the Rasmussen online library, a legal blog, which I just showed you, and the statute of frauds that's been enacted in your own state, which we found in the case. So not bad, not bad at all. Blue book citations for every source. Any questions? Awesome. Excuse me. So module 4, the discussion forum is talking about legalese. You know, as we've seen, again, because the American legal tradition was brought over from Old England. And you can imagine in England, they've got those judges and barristers with those white powdered wigs on. Have you ever seen that? The powdered wigs? And our founding fathers, you know, brought that tradition over from England. And that's why presidents used to wear those white wigs with the powder. How awful. I'm so glad they've taken off those white wigs. So, but there's still a certain stuffiness in some of the language that you'll find in cases and in statutes. And I wish that that could be simplified. In certain cases, certainly here on the West Coast, there is a strong movement towards simplifying language in the law. But there's certainly many places on the East Coast where judges still write in a very stuffy and formal way and a lot of legalese. So the module 4 discussion forum is asking you to find an example of legalese and then simplify it. Let me once again, I'm going to share my desktop and go back into the classroom with you where we started. And we're going to see what your classmates have been posting in this discussion forum. And we're going to take a look at the example of legalese that I posted as well. Okay, so what I posted is an example of legalese is a force majeure clause. That's French. It basically means impossible to perform. So one of the most confusing examples of legalese is seen in these force majeure clauses. Force majeure is a French term meaning greater force. The clause appears in contracts to excuse a person's performance in the event of a natural disaster or unforeseen event. So it means greater force. COVID-19 pandemic represents a classic example of a force majeure event. Accordingly, many people and corporate entities are seeking relief from contractual agreements they previously entered into before the COVID-19 pandemic. So you may have, if somebody was in the business to supply a restaurant with wine, and then the pandemic came along and they had to close the vineyard and they had to close the restaurant. Well, that contract can't be performed anymore because of unforeseen events. And in a contract that is drafted by a competent attorney, there would be a force majeure clause that would say, in the event of a natural disaster, neither party is required to perform, and it would say, you know, who's entitled to damages or what happens in that event. So here's an example. Let me give you an example of a force majeure clause. Companies A, B, C, and XYZ enter into a contract whereby the former will supply the latter with the necessary component parts that ABC imports from the only country where the parts are produced and that XYZ uses in the production of its goods that it sells. What if there's a political conflict or a war? So if I'm in the business of acquiring a very necessary component from the Ukraine, and I'm acquiring that component and I'm going to sell that to my customers in America. Well, guess what? Now there's a war in the Ukraine and I can no longer acquire that component. In that event, the force majeure clause would relieve the company of its obligations to provide that particular product for the period of time that, say, the war remains. And the parties can write into the force majeure contract the terms that they want in the event that a natural disaster occurs and the contract is impossible to perform. But that's force majeure is a real fancy word, and that would be an example of legalese. Here's one that Oceana presented. I retrieved this legalese from the law blog. In witness whereof the parties hereunto have set their hands to these presents is a deed on the day, month, and the year hereinbefore mentioned. And I simplified that. I definitely simplified that. Show replies. Here's my response. Hi, Oceana. What you have presented is a standard document in which two parties provide their signatures to acknowledge that they are witnesses to a deed. That's all that that's saying. All this, in witness thereof, the parties hereunto have set their hands. Basically, at common law, when someone transferred a deed, there needed to be witnesses to the transfer of the deed. So you're asked to present an example of legalese and to correct an example that your classmate presented to simplify it more. And be sure to make those posts by Sunday before the Module 4 discussion ends. Any questions about that discussion forum? Awesome. Let's take a look at how we can simplify language in general. Then we'll have our quiz review. Okay, so problems are often too much repetition, too much complexity, and double or triple negatives. Here's an example of an example with a lot of double negatives. Dale rejects, denies, and refuses to accept that the promise is contractual in nature. Guess what, Joe? Rejects, deny, and refuses all says the same thing, doesn't it?
Yes.
So yeah, we don't need that kind of redundancy, even though they used it in England, even though judges in the East Coast may still use it. We don't need that. The modern trend is to simplify. So how would you simplify this sentence, Joe?
Dell refuses to accept the promise. Instead
There
of
you
using
go.
denies, just use one of them.
Exactly. Dale refuses to accept that the promise is contractual. So yes, the modern trend is toward simplification. I worked in a law firm where, as an associate attorney, senior partners were looking over our work. The same way that attorneys look over the work that a paralegal has done, a senior partner may look over the work of a junior attorney. And the first thing they did is drew a line through everything that I wrote that was redundant or could just be skipped. Anytime you can skip words and still get the same meaning, especially that in nature, that's not needed in that sentence. So if you can make something shorter so that your supervising attorney can read it faster, so that your client can read it faster, so that the judge can read it faster, so that the judge's law clerk can read it faster, that's going to help you win your case. Nobody wants to get bogged down in old legalese that was brought over from England 400 years ago. So if we can just say Dale denies the fact that the promise is contractual. Boom. Short, sweet, and to the point. Okay. Let's have Abigail help us with this next example. At that point in time, whereupon and in the event that the goods are delivered, June shall pay the price. How might you simplify that?
I would simply just state that when the goods are delivered, June will pay the price.
Perfect. I might even add, I would even say contract price. When the goods are delivered, June will pay the contract price.
Yes,
Boom.
that's what I was gonna say. I paused for a second and I couldn't think of it, so I was like, I'm just gonna go with it.
Yeah, price due, something like that. Yeah, so That's what this is all about, is trying to simplify this language. Let's look at another example. I mean, you'd be surprised. This happens a lot. And one of the beautiful things about going in college is that you have the opportunity to refine your writing. You can get rid of all of this legalese. So let's have Sandra help us with number 3. In the event that Jeremy is unable to pay, the contract may be canceled. How would you make that more simple? In the event that Jeremy is unable to pay, the contract may be canceled. How would you simplify that, Sandra?
Let's see here. If Jeremy is unable to pay, the contract will be canceled.
Good. I think that's it. I think that's it. And in the difference between may be and will is important, because saying that the contract may be canceled means that the seller can choose to cancel the contract or cannot choose to cancel the contract. Saying that the contract will be canceled doesn't give the seller any flexibility as to their remedies. So that's where that may be, it might be a better term to use. If Jeremy is unable to pay, the contract may be canceled, because that means that the seller could actually still enforce the contract and sue him for damages.
Right. Yeah.
So that's a great fix. In the event that, no lawyer wants to see that. I'm telling you right now, your supervising attorney does not want to see that language. And they will freak out if you submit a memo with that kind of language in it. Number 4, Abigail, maybe you can help me simplify this one. If either party shall fail to stop breaching this contract, blah, blah, blah.
If either party fails to meet the terms of the contract or agreement.
Fail to stop. That's a double negative, right?
Yes.
What you do with a double negative, they cancel each other out. So just delete it. Read it without those words in it.
If either party.
Come on.
Okay,
Come on.
I do not see it on my screen, so I'm
Oh,
trying
I'm
to
sorry.
remember it from memory. So I'm sorry.
Can everybody see this PowerPoint slide?
It might be my Wi-Fi because it is really
Okay.
bad, so it might be on my fault.
No problem. Let me have Joe do it. Can you see number 4, Joe? All right. So fail to stop. Those are double negatives. Double negatives cancel each other out. So just read the sentence without that fail to stop phrase in it, please.
Without fail to stop.
Without fail to stop.
If either party shall breach this contract.
Perfect. Your supervising attorney will love you if you submit something like that. They will love you because you've gotten rid of all this unnecessary double negative jargon. It's about communicating. You know, one of the best things you can do to be successful in any area of life is to become a great communicator. And when I deal with people on a daily basis, they're usually awful communicators. Awful. Most people cannot communicate. That's why the world looks the way it does. You know, if kids could communicate, would they be out there running into school buildings with guns? No. They'd be communicating about their problems, right? And if counselors could communicate and reach out to mentally ill people, they'd be able to do their jobs, but they can't. And why? Because people can't communicate. If the Democrats and Republicans could sit down and communicate, we might have a government that's moving forward instead of left and right. Who wants to go left and right forever? We're supposed to move forward, not left or right. But that's all we do in America, is we move from left to right. It's because people can't communicate. So when you can become an excellent communicator, you can succeed at anything. And to succeed in the law is to really be an excellent communicator, verbally and in writing. And especially for those of you who want to not only become paralegals, but to become lawyers, it's the communication skills that make all the difference. Because if you are a good communicator, you can walk into court and say, Your Honor, we missed the deadline for filing this, but we're going to file it tomorrow. Is that okay? And the judge had better say yes. It's being able to communicate. And one way to communicate is to get rid of awkward language. So that's what we're working on. And writing these memos is also about communicating. So when you write your memo for Module 4, when you're done, go back and read it. Have your daughter read it. Have your spouse read it. Have your boss read it. Have your dog read it. Use the read aloud function in Microsoft Word. Have someone read it. How does the memo sound? Does it communicate anything? Do you understand what you wrote? Will anyone else understand it? Because, preparing the memo is not just preparing an assignment to submit to me. That's not what it's for. It's for you to learn how to communicate in a way that is persuasive and that somebody else, your supervising lawyer, the court, the judges, or opposing counsel can understand. I used to work with a lawyer who was such a good communicator that he did not want to go to court one day because the court hearing was an hour away from our law office. He didn't want to drive and waste the time. He got on the phone with opposing counsel and said, Hi, we can't make it to court tomorrow, but if we had gone to court, we would have said X, Y, and Z. Since you're right there and you're going to court, can you tell the judge X, Y, Z for our client? Okay, bye. And he had this opposing counsel doing our jobs because he's that good of a communicator. And now we don't have to go to court and waste our time and money driving an hour for some hearing for a case that's not worth that much money. So if you're an excellent communicator, you'd be surprised what you can get done. So that's what we're working on here is trying to simplify our communications and to really, try to say this stuff in a way that people can understand. And nowadays, everything's got to be understood quickly. If somebody doesn't understand it quickly, they won't even take their time. I'm always wondering why. I'm like, why don't people just take their time to sit down and understand what I'm trying to say? But they won't. If they can't get it quickly, then they don't get it, So that's what we're doing here is we're trying to simplify our language for the times that we live in and get the point across quickly. I do not like it, especially if somebody calls me on the phone. If it's a telemarketer and I happen to answer that phone call, the first thing I'm like, okay, shut up. Somebody, when a telemarketer calls you and your phone says scam likely, sometimes it doesn't say scam likely. So I'll answer the call and they're just hurling at me and blah, 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 blah. And I'm like, whoa, stop talking. No, stop talking. I'm like, first of all, you're talking too fast. Second of all, you're not communicating anything to me. So if you were trying to sell me on an extended warranty or whatever you're trying to sell, you're not going to accomplish it. You're going to need to, first of all, tell me who you are, ask me who I am. Am I interested? That kind of stuff. And if they don't do it, I'm just going to hang up the phone. So I really want people to communicate with me in a clear and concise and accurate manner. Now let's talk about these rules of grammar. These are tried and true rules. They've been good for at least the last 100 years. You'd be surprised though, a lot of college students and a lot of adults do not know the rules of grammar, but you need to know them if you want to work in the legal profession, because I can tell you judges know the rules of grammar and they know them very well. So let's take a look at this one. A sentence must have a subject and a verb. The subject is the person who is doing something. The verb is the active word that describes the activity that they're doing. The subject and verb must agree in terms of whether they are plural or singular? Okay, let's take a look. Bob and Tim is friends. Have you heard people say that? Because I have. Bob and Tim is friends. Is that correct English?
No.
Mm-mm. It may work on the street. It may work on Instagram. It may work in a text message. Will not work in a court of law. The judge will laugh the person who writes that right out of the court. No way you can win a case if you don't know the rules of grammar, period. Okay. You cannot work for a law firm if you don't know the rules of grammar. So when your subject is plural, the verb must be plural. Bob and Tim are friends. Okay, now the next one is trickier. Which of these two is correct? Neither Bob nor Tim is going to the party. Neither Bob nor Tim are going to the party. What do you think, Sandra?
I want to say the second one.
Neither Bob nor Tim are going to the party. You think that's correct?
Yeah, but I don't like the neither on it either ways. Either, so. But I think if I had to choose only those two, I would think it's the second one.
Okay, let me show you how to reason through this. This is how we come to truth in the law, also in philosophy. Is the subject singular, Sandra, or is it plural? Neither Bob nor Tim. Is that singular or plural?
Well, would it be plural?
Neither Bob nor Tim.
So it's like deleting them. So well, I would think plural because it's mentioned two people, but singular.
It's actually singular. For purposes of the rule of grammar, neither nor is like either or.
Mm-hmm.
Either Bob or Tim is going to the party. That's singular, and it would be is. So see, that is one of the trickiest ones. I had to look that up myself. I'm not going to lie. I had to look that up. I got on Google to figure that out. Neither nor or either or, that is singular. Either Bob or Tim is going to the party. So that means it's singular. That means the first one is right. The second one is wrong.
Okay.
Are is only when you have a plural, plural subject. So that's a trick question. I think that might be on your quiz though. So neither Bob nor Tim is going to the party. That's considered singular. Let's look at the next one. Shamika walked to school. Shamika walks to school. What do you think, Joe?
Shamika walks to school.
Yeah, singular. When you have a singular subject, you add an S to the verb. Because you hear people say, Shamika, walk to school. I've heard it. You hear, I heard it. I heard it when I was in high school. Shamika, walk to school. And that's not correct English. It's totally fine between friends. It won't work in a court though. No judge is going to rule for anybody that is not using proper grammar, because the judges are old and they went to school when everybody knew the rules of grammar, before there was a Twitter, a tweet, or a text message, or ways of abbreviating it and using slang. They didn't use that. They used correct English. So the judge knows the rules of grammar. That means you have to know the rules of grammar too, so that you can win your case, because it's about communicating and communicating with the person who has the power. You have to communicate on their terms. Nobody that says Shamika walked to school has that much power. That's why I don't communicate with people that talk like that. I'm trying to communicate with the people that got the power and they know correct English. So I think that might be on the quiz, is the rules of grammar. Let's do a quick quiz review, shall we? So we talked about this last week, so I know Joe knows the answer. What are the 3 elements of a valid contract?
Offer, acceptance, and consideration.
Excellent. Do contracts have to be in writing?
No, but they should.
Is that Abigail talking?
Yeah.
They don't have to be in writing, and I don't even think that they should be, you know. I wouldn't even say that. Why? Because in common law, all you need is offer, acceptance, and consideration. You go into Judge Judy with that oral agreement, and she figures out the terms of the contract based on the party's testimony, their credibility, their behavior. So no, a contract does not have to be in writing. It just doesn't. What laws apply to service contracts? Joe?
Common law, I mean,
Yep. Yep. Common law, which is the judge-made law in court decisions. Now, we do have special rules for contracts for the sale of goods over $500. Sandra, what rules apply to contracts for the sale of goods over $500?
Sorry, what was that again? What rules apply to contracts?
Yes.
What rules?
It starts with a U.
Geez, I don't know.
Joe, can you help her?
I'm sorry, what was the question though?
The
What rules?
UCC.
Yes.
Oh, yeah, I knew that.
Good.
Yeah.
You'll never forget that, Sandra.
Yes. Yep.
So,
Okay.
ordinary contracts, the rules that govern those are just judge-made common law that's common to everybody. But because of the importance of the commercial transactions in the American economy, it's very important that commercial transactions be upheld and that commercial contracts be completed, that businesses understand what their duties and obligations are and their remedies. That's all been written out by the legislature in the Uniform Commercial Code, which has been codified in every state except for possibly Louisiana. So it's very important that contracts for the sale of goods be upheld and that there be a free flow of commerce. So that's why those contracts are governed by the UCC, which has some more flexible rules than the common law would have. What is consideration, Joe?
You got me, is accepting the contract. Because you have offer, acceptance, and consideration is that they're both parties are agreeing to the contract. No?
Abigail, can you help us? What is consideration, that third element of the contract?
Isn't it where the party, so the person made the offer and then the person who received the offer reads through it and basically decides if they want to accept it?
You know, I was confused by it when I was in law school. I was like, what are they talking about? You know, consideration is the subject matter of the agreement. It is not what the term means outside of the law.
Okay.
Outside the law, it may consideration mean something entirely different. Consideration would be if we had a contract for the sale of a boat and you're exchanging the boat for money, the boat would be consideration and the money would be consideration. So it's the subject matter of the contract, Abigail. It is the thing of legal value that we're bargaining for. So if I agree to pay my next door neighbor $20 to mow my lawn, I'm bargaining for him to come mow my lawn. He's bargaining for the $20. That's the consideration. It is what supports the mutual promises that we're making, which is that we're exchanging something of legal value. That's what makes the contract enforceable, that we are exchanging something of legal value in exchange for the promise to perform. So the consideration is the subject matter of the contract. It has an entirely different meaning than it would otherwise. Okay, well, why should you put a contract in writing, Abigail?
Because it provides like a clear outline of the terms of agreement between each parties, and it's right there with physical proof to show that.
Excellent. And under the statute of frauds, we just learned that 6 types of contracts have to be in writing. And the acronym is MyLegs. Contracts for marriage, contracts that cannot be performed within a year, contracts for the sale of land, executor agreements, guarantee or suretyship agreements, contracts for the sale of goods greater than $500. All those have to be in writing anyway. So that kind of makes it look like your contract needs to be in writing, at least to satisfy the statute of frauds. What should a paralegal do, Sandra, if she finds an error in a contract? If you're reviewing a contract, and let me tell you, when I worked in a law firm and somebody asked me to review a contract, I was always extremely annoyed. I'm like, you're kidding. One time they told me, go through a bunch of boxes and find the contract between the architect and the general contractor. You know, what? You know, it was a contract that was probably written 10 years earlier. I had to dig through a bunch of boxes and find this contract. It was boring. And then they were like, we need you to look over the contract. But anyway, what should you do if you find an error in a contract?
I think I would right away let my supervising attorney know.
Yes, yes. Hopefully you will not be asked to review contracts. There are, if anybody wants to review contracts, I'm always seeing those jobs listed on, you know, websites where they're looking for, if somebody was looking for a part-time job that pays a lot of money. Law firms are always looking for temps to review contracts. I find that work to be very, very tedious and boring, especially, like I said, if you're working on a project, you know, where if it's a construction project, there's a bunch of contracts. For example, when a mall gets developed, somebody has a development project, there's a lot of contractors, a bunch of subcontractors. There's a contract for plumbing, one for nails, a contract for lights. There's a contract between the architect. There's a lot of contracts. And when you have to do contract review, you know, you have to find these contracts and dig and review them. Anyway, there's a great need for people that want to do that. So if you ever want a job reviewing contract, you could probably do that job from home. You just look on Google and see who's hiring, because I see that a lot. They're wanting people to review contracts. Let me tell you, it's boring. Anyway, hopefully you won't have to do that. IRAC is an acronym for what, Joe?
It's issue, rule, analysis, and conclusion.
Yes, ma'am. Why do we use IRAC tables in Microsoft Word, Sandra?
To break it down, to make it easier.
Absolutely. You can find out what facts you might need, what questions you might still need to ask a client. It's very helpful for analyzing the issues in the case, what information you still need. What is a restatement second of contracts? It is a treatise. Treatises are secondary sources of the law. When you want a primary source to the law, you read the statute, which is the law from the mouth of the legislature. If you want a primary source of the law from the judges, you read a case. Now we have encyclopedias that summarize the law. Those are treatises like the restatement second of contracts. Why do we use Lexis Advance and Fastcase, where they're boutique legal research services that are supposed to be more reliable, user-friendly, easy to get the information, and is accurate? Under the UCC, what are the seller's duties? Well, the seller has to tender delivery of the goods, and the goods have to be conforming. So the seller's duty is to tender delivery of conforming goods. The buyer's duty is to accept the shipment and pay. Okay, that's the end of our quiz review. I took the quiz, and that's what I remember as being important to study. So just be sure to review these 2 PowerPoint slides. I'll share the PowerPoint and send it out to everyone. Just review those 2 slides, because that's what I remember being on the quiz when I took it. And we have reached the end of our live session, right on time at 6 o'clock. my time, which is 8 o'clock your time, or maybe 9 o'clock. So in order to get credit for the Module 4 live session, this is a time when the module is asking you to submit the correct answer to the live session question. The question is, what are 3 remedies the buyer has under the Uniform Commercial Code? The best way to find that answer is to Google it. What are 3 remedies the buyer has under the UCC? Google will give you the correct answer every time. So just questions?
Nope.
Awesome. Well, thank you so much, ladies, for participating in the Module 4 live session. You all did a great job of answering these questions and interacting. And the people who attend the live sessions usually get higher grades. That's what I have seen year in and year out, because you're getting it from the horse's mouth. It's another learning style. It's audio visual learning and hands-on. So it's great to attend the live sessions, especially if you want to do well in the class. So thank you so much for being here. If you have any questions or concerns, my e-door is always open. You can send me a text message, send me an email, and I will respond to you right away. If you need help doing research, you can contact Dennis, the librarian. You can always set up a tutoring match appointment for yourself. So just let me know if there's anything I can do to help. Have a great weekend.
Thank you.
You too. Thank you.
Bye, Abigail.
Bye-bye.
Bye, Sandra. Bye, Joe. Bye.
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 Bye.